And you know what time it is? It's time for KP's Video News. KP's Video News, y'all. KP's Video News, y'all. KP's Video News, y'all. Right.
That's right, folks. Time for KP's Video News. And what's shaking, you know, today. I said I wasn't going to get hung up.
And you know what time it is?
I wasn't going to get hung up on trying to, you know, get caught up in the madness, man. Everybody's been going through this whole phase of, you know, comparing apples to oranges and dealing with all, you know, with the outcome of the Maxwell House trial up there in Minnesota, Milwaukee, wherever the heck it was, Wisconsin, wherever it was. Anyway, yeah, I said Maxwell House. I'm telling you, man, you know, it's kind of hard to stay away from it, the topic. I really tried my best, but these stories, man, just keep coming. And so this particular, I have two stories in particular that I'm going to lead with. And this first one is, you know, has to do with the black man charged with murder. And it said, you know, that he was shot at by a group of white teens, and he shot back in self-defense. And so, you know, you had some high-profile cases, man, that you know ended up in acquittals. Now let's see if the same thing is going to happen for this young black man who killed a white teen in Georgia around 1 a.m. on June 14th in 2020. 21-year-old Marc Wilson, who was black, and his 21-year-old girlfriend, Emma Risden, who was white, left a Taco Bell in Statesboro, Georgia. And at a stoplight, they pulled up next to a pickup truck. And at least one of the white teenagers inside the truck shouted N-word and "your lives don't matter." Wilson later stated that the teenagers in the pickup truck swerved in front of him, tried to knock his car off the road, and threw an object that impacted the car with a loud sound and made him think that he might be shooting at him. Wilson pulled out a gun, fired out the window at the truck, and the bullet struck and killed a 17-year-old Haley Hutcherson, who was sitting in the pickup's back seat. Prosecutors charged him with felony murder and aggravated assault, with which carry a maximum sentence of life in prison and the possibility of the death penalty. Wilson claimed self-defense. And so it said, you know, me and my girlfriend were very scared that night. Wilson told the police later that week, according to the detective's testimony, everything is going on in this country. I'm not going to let me and my girl get run off the road. Wilson was denied bail because the circuit court judge, Michael Muldrew, concluded that he possesses a significant threat to the community. He remained in jail 2 months. Later, when an officer in Kenosha, Wisconsin, shot and injured Jacob Blake, a 29-year-old sparkling protester, protests in that city drew armed counter-protests, and Kyle Wittenhouse, Maxwell House, a white 17-year-old who fatally shot Joseph Rosenbaum, Anthony Huber, Rittenhouse, who made a $2 million bond with the help of donation from supporters, claimed self-defense, testifying that he feared for his life. And on Friday, the jury acquitted him of all charges. Wilson's case, which is scheduled to go to trial in early 2022, presents a similar legal defense. A young person says he fired his gun at a group that threatened his safety. But in a justice system that has historically treated black defendants more harshly than white ones, Wilson's case raises the question of whether a young black man's self-defense claim will carry the same weight as those made by other recent high-profile defendants. Self-defense laws including the Castle Doctrine and Stand Your Ground provisions, offer legal justification to kill people who pose a physical threat. Castle Doctrine is based on the idea that a person has a right to defend their home if they're in imminent danger. In 1994, Utah passed a law that extended that right to self-defense to any place a person has a legal right to be. Florida followed in 2005. To date, 34 states have similar laws in place. Georgia states that a person is justified in using force if he or she reasonably believes that such force is necessary to prevent death or bodily injury. The white men who followed and fatally shot Ahmaud Arbery, a 25-year-old, while he was jogging near their neighborhood in Glenn County, Georgia last year, have also claimed self-defense and are currently on trial for charges that include murder. Who is protected by such laws often depends on race, says the law's critics. In 2020, the United States Commission of Civil Rights released a study of racial disparities in Florida's Stand Your Ground law, finding that homicides in which the shooter is white and the victim is black were ruled to be justified 11% of the time, compared to just 1.2% of the time when the shooter is black and the victim is white. What we do know and what we cannot ignore is the same racial biases that have permeated our criminal justice system cannot be separated from this issue. So, you know, it's crazy, man. Crazy. I'm gonna follow this case. That case goes on trial, but this case, this is another case here that brought, you know, that came back up, and so people are turning back to this case right here, the case of Crystal Kaiser, who is also arguing it was self-defense when she killed her adult sexual abuser. So Kaiser was 17 at the time, is accused of shooting Randall Villar in the head. Villar had previously been arrested on child sexual assault charges. Kaiser was released from jail in June of 2020 after groups such as Chicago Community Bond Fund raised money to pay her $400,000 bond. She's still awaiting trial. Prosecutors say the killing was premeditated. But what's notable in this case is that Kaiser's lawyers are invoking a self-defense argument that has never been used in a homicide case in the state before. Originally, Kenosha County Circuit Judge David Wilkes said Kaiser could not use the affirmative defense argument in this case because it involved homicide. But Wilkes' decision was overturned by an appellate court that ruled that per state statute, Kaiser can argue affirmative defense if her attorneys can show that her actions against Villar were a direct result of the trafficking she experienced. Wisconsin Supreme Court is currently reviewing the case. What protesters are saying: protesters spent the weekend chanting the names of Maxwell House victims, and as well as Kaiser's name, and members. People reported their argument is that if Maxwell House successfully argued his case claiming self-defense, then Kaiser's case should have the same outcome. Crystal Kaiser was in the building advocating for her justice too. And Democratic State Representative David Bowen said, and we didn't hear any of y'all, and we didn't hear anybody that was making noises, any noise. And Kaiser's case also brings up the test of how the law can oftentimes not apply equally to everyone, particularly black girls and women like Kaiser. Sherilyn Grace, who was a former executive director of the Chicago Community Bond Fund, stated last year that Kaiser's case is important to highlight. We see these cases as incredibly important to protect and uplift and support individual women who are overwhelmingly black women, because the reality is that Crystal Kaiser was not kept safe by police and prosecution and incarceration, and in fact she was forced to defend herself and she chose to survive. She was then further harmed by those systems. So I'm telling you, man, it's a crazy situation. Those are two cases I'm going to be watching. Marc Wilson and then the Crystal Kaiser case there. Keep my eyes on those two cases, man. Make sure I keep my eyes on those two cases. Now this here goes to this is in Aurora, Colorado, and you know, I lived there for a while. I never experienced it, but you know, things were a little bit different then, you know, compared to now. And here we have a the head of the Aurora Police Union was suspended after sending a letter complaining about diversity requirements for the police department. Aurora, Colorado has been fielding several scandals that has been ushered in a series of changes to the department that evidently triggered police union President Doug Wilkinson, who sent an email complaining about diversity hires. To match the diversity of the community, we could make sure to hire 10% illegal aliens, 50% weed smokers, and 10% crackheads, and a few child molesters and murderers to round it out. So we can make the department look like the community. This is what he stated. This is what this Wilkinson, Doug Wilkinson, president of the police union in Aurora, Colorado. This is what that's what he stated. Officers complained to Human Resources, handing over the email, and Wilkinson was put on leave with pay the next day. We've seen the letter, Lieutenant Chris Ambler stated, and the Chief Vanessa Wilson is very concerned about the allegations that have been brought forth by several concerned and courageous employees. Due to the sensitive nature of this ongoing investigation, we cannot discuss the case further. We would like to remind the media and our community that the Aurora Police Association does not speak for the Aurora Police Department, nor are they recognized bargaining unit with the city of Aurora. That's odd. More public scandals began in 2019 when police officers killed a 23-year-old Elijah McCain. Someone called 911 saying McCain looked sketchy and was wearing a ski mask and waving his arms. Police arrived, and before the night was over, McCain was dead. The three Aurora officers then recreated the slaying at the memorial site for McCain that they posted on social media. McCain's death prompted an investigation to the Aurora Police Fire Departments because they did not only did they suffocate McCain, the EMTs who arrived at the scene injected him with ketamine. He was never suspected of a crime. Investigation into the department found a pattern of racially biased policing and the use of excessive force. An investigation also revealed the fire department's EMT regular use of ketamine was unlawful. The police and fire department's behaviors have sent shockwaves through the community. And in the wake of the investigation, the attorney and the city entered a consent decree mandating that the police department be reformed and implement specific hiring and training practices. And the requirement will remain in effect for 5 years. So the city of Aurora is under a federal consent decree. So, you know, that's something that Trump and William Barr basically got rid of. And thank goodness that we got Joe Biden in there now, and his Department of Justice has started re-implementing these consent decrees that basically put these police departments in check. So here's on to the next one. This is Kansas City. So when asked about the manslaughter case against Kansas City Police Detective Eric D., Chief Rick Smith always said that it was a prosecution based on nothing and going nowhere. All politics, he told everyone who asked, and certainly nothing to worry about. That's not how Jackson County Circuit Court Judge Dale Young saw it. He found that Officer D violation of Cameron Lim's Fourth Amendment rights rather a big concern. And last Friday, he found that the Kansas City Police Department veteran DV guilty of killing Lamb in 2019. 9 seconds after arriving in the man's own backyard, where the officer had no reason or right to be. In court, Officer DV's defense team argued that every single Kansas City police officer would have done exactly as he did. And based on the chief's response, we're inclined to agree, which is even a larger problem. What Officer DV did was to charge in the Lamb's backyard, gun drawn, without any permission, warrant, or probable cause, as if Lamb's basic protection from unreasonable search and seizure didn't exist. He had DV claimed on the stand that he had every right to be there because Lamb had been seen speeding after another car and might be dangerous. We believe that because that's how he had been trained. That's how he saw the job, which makes Smith at least as wrong as DV, who will soon be behind bars. For 16 months, we have been arguing that Smith can no longer lead this department. In July 2020, we said Smith's supporters keep saying his officers love him. Of course they do. If you're indicted in a fatal shooting for excessive use of force, he'll defend you and refuse to fork over the necessary charging documents. But the correct term for that is obstruction of justice. Even in the unlikely event that the toothless, opaque Office of Community Complaints find you were in the wrong, Smith will override that too. Law enforcement that exempts the guys with guns and badges from accountability was never okay, and his department's public position that police shootings are by definition justified shootings and untenable. So is his non-relationship with Jackson County prosecutor Gene Baker, who says, I have tried but have gotten nowhere with Smith. Smith is hugging his officers to death. And so for the good of Kansas City, said the mayor did have it upside down, Lucas said, because the police board members can't keep their heads in the sand and pretend that the status quo is sustainable. For the good of all Kansas City citizens, Smith now has to resign or be fired because, as those black officers said, nothing can change while he's running the department. With a new member on the board of police commissioners, Don Kramer, comes a new opportunity for the accountability that the board has never before shown any interest in imposing, and there would be nothing anti-police about saving the Kansas City Police Department from the kind of mistaken view of its mission that it is about to be sent one of its own to prison. And so that cop is going to prison, and the police chief was just like trying to say, oh, he's a good boy. All right, here's my feel-good story of the day. The jury awards $25 million in damages for Unite the Right violence. That's right, folks. Charlottesville, Virginia. A jury ordered the white nationalist leaders and organizers to pay more than $25 million in damages. That's right. Today, over violence that erupted during the deadly 2017 Unite the Right rally in Charlottesville. After nearly month-long civil trial, the jury in the U.S. District Court deadlocked on 2 key claims, but found the white nationalism nationalist liable on 4 other counts in the lawsuit filed by 9 people who suffered physical or emotional injuries during the 2 days of demonstrations. Attorney Roberta Kaplan said the plaintiff's lawyers plan to refile the suit so a new jury can decide the other 2 claims this jury could not reach a verdict on. she called the amount of damages awarded to the others eye-opening. That sends a loud message. The verdict, though mixed, is a rebuke to the white nationalist movement, particularly for the 24 individuals and organizations who were accused in the federal lawsuit of orchestrating violence against African Americans, Jews, and other meticulously planned conspiracy. White nationalist leader Richard Spencer vowed to appeal, saying the entire theory of that verdict is fundamentally flawed. He said plaintiffs' attorneys made it clear before the trial that they wanted to use this case to bankrupt him and other defendants. It was activism by means of lawsuits, and this is absolutely outrageous, he stated. Man, this is beautiful, man. This is making my day. Lawyers for the plaintiffs invoked a 150-year-old law passed after the Civil War to shield freed slaves from violence and to protect their civil rights. Commonly known as the Ku Klux Klan Act, the law contains a rarely used provision that allows private citizens to sue other citizens for civil rights violations. Hundreds of white nationalists descended on Charlottesville for the Unite the Right rally in August 11th and 12th of 2017. And the protest, the city plans to remove a statue of Confederate Robert E. Lee during a march on the University of Virginia campus. White nationalists, chanted and surrounded counter protesters and threw torches at them. The following day, they had admirer of Adolf Hitler rammed his car into a crowd of counter protesters, killing one woman and injuring dozens more. Then President D.C. Dunce touched off a political firestorm when he failed to denounce the white nationalists, saying they were very fine people on both sides. The driver of the car, Alex Fields, is serving a life sentence in prison for murder and hate crimes. Field is one of the 24 defendants named in a lawsuit funded by Integrity First of America, a nonprofit civil rights organization formed in response to the violence in Charlottesville. The lawsuit accused some of the country's most well-known white nationalists of plotting the violence, including Jason Kessler, the rally's main organizer, Spencer, who coined the term alt-right, and to describe loosely connected band of white nationalists, neo-Nazis, and others. The Christopher Cantwell, white supremacist who became known as the Crying Nazi, for posting a tearful video when a warrant was issued for his arrest on assault charges for using pepper spray against the counter demonstrators. The trial featured emotional testimony from people struck by Field's car or witnessed the attacks, well as plaintiffs who were beaten or subjected to racial taunts. So, yep, 25 mil. The white nationalists maintained there was no conspiracy in their blustery talk before the rally was just rhetoric and protected by the First Amendment. Before the trial, Judge Norman Moon issued default judgments against another 7 defendants who refused to respond to the lawsuit, and the court will decide damages against those defendants as well. It's a beautiful day in the neighborhood. Oh yeah, it's a beautiful day in the neighborhood, folks. And this KP's Video News. $25 million against the white nationalists, and $25 million in damages. Pay the man. That's right. That made my day.
And you know what time it is? It's time
made
for
my
KP's
day.
Video News.
That's right. Happy Thanksgiving.
KP's Video News, y'all.
Happy Thanksgiving, y'all.
KP's Video News, y'all.